Now, none of these oaths and bonds can be taken in truth, for if they may be safely taken in any sense, it must be such as the oath and the design of the imposers cannot bear, and which the imposers never intended, nor would they ever have allowed if they had understood it, which industriously the takers have a care they should not understand, and so they must take it in that sense with a mind to deceive, which cannot be in truth, but most derogatory both to the truth and simplicity of the gospel. And they are all unclear and ambiguous, which cannot be taken in truth, because they have no truth in them. As Dr. Sanderson saith, De Jure Promise Obligation Prael 6, section 10, quote, "A proposition of an ambiguous and indefinite sense before the matter be distinguished is not a true proposition, yea, nor a proposition at all. For a proposition, as its definition cleareth, should signify either a truth or a falsehood without any ambiguity. And therefore, says he, such oaths should be suspected, that there is some deceit lurking, and every pious and prudent man should refuse them offered under such terms." Unquote. Cited by Apologetic Relations, section 10, pages 118, and section 15, page 267. In fine, none of them can be taken in truth, since they are all a denying the truth, as will be evident by the induction of all of them, which, how it can consist with the fear of God or sincerity of heart, cannot be imagined, and if conscience be called into judgment, it will condemn the taking of them. Secondly, they cannot be taken in judgment. It is that, with knowledge and deliberation, minding and understanding, what it is we swear or subscribe, as Mr. Durham explains it in the place above cited. For first, they cannot be taken in judgment because they are all ambiguous, the terms of them being capable of diverse senses, not explained by the imposers. And if they were explained in their sense, then they could not be taken in righteousness, and so at best they are uncertain. That is dreadful, to invoke the majesty of God to be a witness to uncertainties. For that is to swear with an evil conscience and contempt of God, to dare to call him in as a witness of that which is in suspense, whether it be truth or a lie, and such a swearer must make it a matter indifferent, whether he make God a witness of a truth or of a lie in the case. Vide Paream, Loc Sup, cite page 754, section 4. Dr. Sanderson, as before, gives these reasons further against all ambiguous oaths, quote, "Because of him who tendereth the oath. For the proper end of an oath is, that he in whose favours it is taken should have some certainty of that whereof he doubted before. But there can be no certainty out of the words, which have no certain sense. Next, because of him who sweareth, who, if he take such an oath in these terms, either stumbleth his neighbour or spreadeth the net for his own feet. For to what else should such confusion tend, but either that by our example others may be induced to take it, whereby they are stumbled, or that afterwards by virtue of that oath something may be required of us, which is either unlawful or hurtful, and this is to lay a snare for ourselves. Therefore let every prudent man beware of suffering himself to be deceived by these wiles, and of thinking so much either of the favour of the ill will of any other, as to swallow the bait under which he is sure there is a hook. It is expedient that, in the matters of oaths, all things be done aright, and that the sense be clear to all, and that is, to swear with a clear conscience." Unquote. Apologetic Relation, page 267. But next, they cannot be taken in judgment, because they are all imposed and extorted under a severe penalty, and some of them of death, and so must be taken out of fear. Such oaths are by many famous divines judged unlawful, especially public oaths imposed by authority, and under colour of law. These are worse than a man's private oath given to a robber for fear of death, if the matter be unlawful. For without the matter be lawful or unlawful, such oaths, coacted, exacted, and imposed by law, cannot be taken in judgment. For if they be taken out of respect to the law, then it is the person's suffrage to the equity of that law, and an approbation of the imposition, which, in the present case, cannot be done by any man of conscience. For whether the oaths be lawful or not, the authority imposing them is naught, and the law wicked, and can never be approven. And if they be extorted out of fear, then they cannot be taken with deliberation, or voluntary and unviolented choice, unconstrained delight or liberty, which are all the ingredients of judgment. Thirdly, they cannot be taken in righteousness, that is, according to the law of equity as well as piety, neither wronging God nor others by our oaths. Lawful oaths should be in themselves ties of equity as well as truth. And Pareus saith, In the place before cited, lawful oaths are only these which are engaged into about things true, certainly known, lawful, possible, weighty, necessary, useful, and worthy. And if that be true, then are all the oaths and bonds taken these many years but fetterings into bonds of iniquity, which, when the conscience of the takers will reflect on them, will become galls of bitterness, and found to have none of these qualifications, but on the contrary, to be about matters false, uncertain, unlawful, impossible, frivolous, fruitless, useless, and unworthy, to the worst degree of baseness, and, which is worst of all, dreadfully sinful and horrid, to be thought on to interpose the name of God upon, making him the approver of what his soul hates, and a witness of that which he will be an avenger of, as will appear by the particular consideration of all of them. Second, let it be considered that though, as the pleaders of these transactions do impertinently, allege the same words in other cases might be subscribed in a more abstract sense as being capable of a good construction, yet complexly considered in the form and frame of all the oaths and bonds we have been troubled with, they cannot be subscribed in any sense, and if in any, that must be the imposer's sense, which in them all is always pernicious. First, they cannot be taken in any sense, though never so good, if we consider the absolute illegality of their arbitrary imposition. It will be confessed that oaths should be very tenderly imposed upon consciences, not only lest the name of God be prostitute to profanation in matters light and trivial, or dubious and uncertain, but lest a tyrannical jurisdiction be exercised over the souls of men, which are not subject to any power that mortals can claim. So it cannot be denied, but that the constitution of our government requires, and reason as well as religion says it is necessary, that no ruler hath right to enjoin an oath which is not first enacted into a law, and it was always accounted a good plea for refusing oaths when there was no law for them, and some have been charged with treason for exacting oaths without a statute ordaining them, which might be brought in as a charge against all the imposers of our oaths, the most part of which have been enacted and extorted without any color of law, some of them being never ordained by any act of Parliament, and others of them before they could obtain such a mischief framed into an act for them, and all of them neither ever legally administered nor righteously enacted by such who had power to make acts. For as for the packed parliaments that made them, no conscientious man could ever own such a company of perjured traitors to be their parliamentary representatives. Yet, abstracting from that, I say, the oaths that have been imposed without and against law could never be taken in any sense, without consenting to their treasonable breach of law, for which they have forfeited their lives to justice, whenever there shall be a judicatory to revise their administrations. And these that have been imposed by a pretended law could never be taken without justifying of that law that ordained them, which hath been nothing but a mischief, framed into a law by a throne of iniquity. Number 2. They cannot be taken in a good sense with a safe conscience, considering either what is plain in them or what is more ambiguous. What is plain and capable but of one sense, that is, always either restraining to a clear sin, to renounce some part of the covenanted reformation in profession or practice, or constraining from a clear duty, that we should not do that which we may or ought to do. There is nothing in all of them plain but what obliges to one of these two. Again, what is ambiguous in them, as it ought to be refused for its ambiguity. So, when it is explained according to the imposer's mind and meaning, the sense will be found always pernicious, through the word, though the words may be plausible, as when they require an obligation to allegiance or loyalty or peaceableness or orderliness and other smooth words, signifying excellent things in an abstract notion. These will be found to carry quite another sense, if we inquire into the imposer's meaning, in which only oaths and bonds must be taken. The only way to find out their meaning is to consider either their acts or actings, or their designs and intentions, as they are discoverable by any man of prudence or consideration. If we consult their acts or actings practically, and not only legally, explaining them for a commentary, then by allegiance, we can understand nothing else but an owning of their absolute tyranny. By loyalty, nothing but an absolute and implicit obedience of their absolute commands without reserve, as the late proclamation for the toleration expounds it. By peaceableness, nothing but a stupid subjection to them, letting them do what they please without resistance or control. and by orderliness nothing but a disorderly compliance and conformity with them, in going along with the corruptions and defections of the time, for their acts and actings expound them so. If we consider their designs and intentions, according to which they are all uniformly calculate and equally level, he is blind who hath not seen that they have been driving all this time at these designs, to which all these oaths and bonds have been adapted and successfully subservient, by which they have been promoted to the present pass, to overturn gradually all the degrees of our covenanted reformation, to establish tyranny and advance it unto greater degrees of absoluteness, and to introduce popery and slavery, so that by allegiance and loyalty can be meant nothing else but an obligation to own and obey, and never to oppose the design of advancing tyranny, and by peaceableness and orderliness nothing else can be intended than an obligation never to oppose either the present settlement or future establishment of popery and arbitrary power upon the ruins of the Reformation, and our civil and religious rights and liberties. Whence, they that can take these oaths and bonds in any other sense, and plead for the inoffensiveness of the terms, in a more abstract notion and sense alleged more legal, without regard to that of the imposers, practically explained by their administrations, and so looking more to the briberies of their blinded reason and worldly interest than to the dictates of conscience, please themselves with such notions and quibbling evasions, do but mock God, deceive the world, elude the enemies, and delude themselves. And all these debatings for accommodations and expositions in another sense are but soul fairdings and conscience beguiling compoundings in and pitiful priggings for a base compliance. But it is usual for a guilty son of Adam to sow fig leaves. Fourthly, let it be considered that all these oaths and bonds that the land hath been debauched with these 27 years are all condemned by and contradictory to anterior binding orders and acts of the General Assemblies requiring no oaths in the common cause to be taken without the Church's consent, as was cleared in the historical part upon the 5th period, page 97, and that especially they are condemned as being contradictory to and violatory of prior oaths of continuing indispensable obligation, being designed, pressed, and imposed on purpose to delete the same, out of the minds and memories of the present generation. I mean the National and Solemn League and Covenants, and other former nationally binding public engagements, which, because they are not only broken and burned, but declared criminal to be owned, and because the owning of their obligation is ordinarily inserted in the indictments of our martyrs, I must touch upon them more particularly. It was cleared above, Head 1, Argument 11, from the form, the object, and from the ends of the covenant, which are all moral and indispensable obligation, that it is of perpetual and unalterably binding force, obliging the present and all future generations, as well as that which did first come under the bond of it. And to confirm this, I shall add more particularly these many considerations. Number 1. The national engagements are national promises, plighting and pledging the nation's public faith for the preservation and propagation of religion and liberty to succeeding posterity, which, if succeeding generations may reverse, then the faith of men and the faith of nations can be of no force above a century of years. Nay, nor after the decease of them that personally made the promise, and so every new ruler, every new parliament, yea, every person coming up to succeed the father in any capacity, might be free not to stand to it, which were very absurd. Certainly that promise of the Jewish nobles and rulers not to exact usury on their brethren, but to restore and not to require it of them, did not only oblige themselves, but would bring their posterity under the curse if they should exact the same debt there remitted, Nehemiah 5, verses 12 and 13. And does not a national promise of preserving the Reformation bind as much to the curse of the breach of it? Second, they are national vows, avowing and avouching, and devoting themselves and their posterity to be the Lord's people, and to keep his statutes, and promote his interests, which do bind posterity.